A new crime law in Alabama that passed without police and prosecutors knowing much about it. They don't like it and say it threatens public safety.
Several lawmakers who voted for it say they're not sure now why they did, and the state senator who came up with the idea doesn't want to talk about it.
It was a horrible and highly publicized crime. 5 shots at a high school football game last fall at Lad People Stadium.
Now, Mobile police released this picture today asking for help identifying these 3 persons of interest.
3 people are accused, 2 19-year-olds, Jai Scott and Hezekiah Belfon, and a 17-year-old whose name cannot legally be disclosed by police or the media due to a law that went into effect just 10 weeks before the shooting.
For decades in Alabama, a 16 or a 17-year-old charged with a serious crime like murder or rape has automatically been treated as an adult. In Mobile, brought not to the Strickland Youth Center, but here to Metro Jail, and then tried as an adult.
That's still the case, but those minors can no longer be named, even during their trial, unless and until they're found guilty.
I don't know very many chiefs that I've talked to that was aware of it before it happened.
Police and prosecutors usually have major input on a law like this, but they say they knew nothing about Senate Bill 206 that passed overwhelmingly in the 2021 legislative session. They say it was a big mistake that threatens public safety.
If this individual was to make bond and show up at school next week, I think it's important that the community knows those things.
More often than not, they're going to get a bond. They're going to go right back into their same neighborhood or community, and I think neighbors need to know who's living next to them.
And it's not just the threat a violent teenager may pose while out on bond. Take the case of LaCraig Brown. The Atmore man was killed outside a restaurant in Pritchard in September.
Not being able to identify juveniles.
Pritchard detective Robert Martin says he knew who killed Brown within days, but it took 5 months to find the 16-year-old because police couldn't publicize his name or have his picture shown on the news.
Most of the times we can apprehend that subject rather quickly because people will say, hey, I know this person, or I know where they are.
The juvenile protection bill was sponsored by Senator Will Barfoot, a Montgomery attorney who's defended juveniles. He did not want to talk to us about his law, but other criminal defense lawyers did.
And I applaud the legislature for what they've done.
Chase Dearman of Mobile says children should never be subjected to the same legal standards as adults.
Simply because they do what prosecutors label an adult crime, a child is the one that did that, with a child brain, undeveloped.
Seemingly agreeing with Dearman, not one state rep nor senator from the News 5 viewing area voted against the bill. But now, at least 2 say they wish they had.
That's probably something we need to revisit.
Chris Elliott says this law needs to go.
There are times where what you think is going to be the impact of a piece of legislation is not really what happens.
Greg Albritton of Atmore is another who thinks the law may need to be repealed. He admits he's not sure how it passed in the first place.
How did that kind of go through without the police chiefs and the DAs having much input on it?
Good question. Good question. Somebody let it get by.
Florida allows kids of any age to be named if they are charged as an adult with a felony.